Good morning. Today we are going to start with the topic rights of an unpaid sailor. Before seeing the rights, we should first know who is an unpaid sailor. Okay, a sailor of goods is deemed to be unpaid sailor when the whole of the price is not paid to him. Okay, or bill of exchange has been given to him or a check has been given to him, means instrument which is called as a negotiable instrument, those are given to him, and those instruments, that bill of exchange or a check, is being dishonored, then that sailor will be called as an unpaid sailor. Means unpaid sailor is a person whose price is not paid, or a check is being given to him, a negotiable instrument has been given to him, and that is being dishonored. That person, that sailor will be called as an unpaid sailor. Okay, now there are certain conditions which are to be fulfilled before a sailor can be deemed as unpaid sailor. What are those conditions? Three conditions are there. First, he must be unpaid. It means the price must be due and the price is not paid to him. Okay, that is first. He must be unpaid and the price must be due. Second is what? He must have an immediate right to file an action for price. That is the second. And the third is a bill of exchange or a negotiable instrument is been given to him and that is been dishonored. Such a sailor will be called as an unpaid sailor. Okay. Now the rights of an unpaid sailor are towards, or you can say against, the goods and against the buyer personally. Means he is having two basic rights. One, he can exercise certain rights against the goods. The other is he can exercise certain rights against the buyer personally. First we will see the rights of an unpaid sailor against the goods. Okay. Now against the goods, what right he has? Before we are going to exercise those rights, we should know whether ownership has passed or ownership has not passed. Okay, that is property in the goods has passed or not. Means when the unpaid sailor is having rights against the goods, first we have to see whether property in the goods has passed, that is ownership has passed or not. And the second is where the property in the goods has not passed. Now we divide here those rights. I'll repeat again. Right of an unpaid sailor against the goods is to be divided into where the ownership has passed and where the ownership has not passed. Okay, now first we will see where the property in the goods has passed. Means where the ownership has passed, he is having three rights. First is right to lien, second is right to stoppage in transit, and the third is right to resale. Okay, now these are the three rights where the ownership has passed. Now the other, that is where the property in the goods has not passed, means the ownership is not yet passed to the buyer. At that time the sailor himself is the owner of the property. Okay, now in this case if he has been unpaid, then what right he has? He is having two rights. One is withholding delivery and the other is stoppage in transit. So stoppage in transit is a right which is available to the unpaid sailor in both the cases, whether ownership has passed or ownership has not passed. Okay, and withholding delivery means he will not give the delivery of the goods to the buyer. Okay, that is one right which is there when the ownership has not passed. I'll repeat again. Where the ownership has passed, he is having three rights: lien, stoppage in transit and resale. And when the ownership has not passed, he is having two rights, that is withholding delivery and stoppage in transit. Okay, we'll go one by one. The first is right of lien. Now what is a lien? Lien means to keep the possession of the goods until the payment is made, until the price is paid. See, a lien is a right to retain possession of goods until payment of price. Now it is available to the unpaid sailor only in certain circumstances, and that is what the first. The goods have been sold without stipulation of credit. Means the goods are being sold by the sailor and the sailor says, I'm not giving you the credit, you pay me the price. In such a condition, in such a circumstances, he is having a right of lien. The second is where the goods have been sold on credit and that time has expired. That the credit was given for 2 months. The sailor had given 2 months to the buyer so that he can pay. but the buyer has not paid, 2 months have lapsed, 2 months are over, then he is having right to lien. Okay, so goods have been sold on credit, but the term of credit has been expired. That is the second. And the third is the buyer has become insolvent. Means when the unpaid seller is having possession of the goods, he can exercise right of lien when the credit is not being given. Second, the credit is being given but the time has expired. And the third is when he becomes insolvent. When the buyer becomes insolvent, the seller can exercise right to lien. Now, right to lien, there are certain rules of right to lien. When lien can be exercised? When only possession is there. So, when the goods are in possession of the seller, then he can exercise the right of lien. Now, this possession can be of the agent of the seller also, or servant of the seller also. Okay, so this agent who is going to exercise the right of lien on behalf of his principal, that is the seller. The seller may exercise the right of lien notwithstanding he is in possession of the goods as an agent. Okay, so lien can be exercised by agent also on behalf of principal, that is the seller. That is the first rule. The second is lien depends upon possession. There must be possession. If possession is there, then only lien can be exercised. There is no requirement as to title. So possession is there, lien is there. Okay. If possession is lost, then lien is also lost. That is the second rule. The third is the possession of the goods by the seller must not expressly exclude the right of lien. Means in between the buyer and the seller, first they enter into contract, and in that contract they have clearly mentioned that the seller will not have right to lien. If they agree for this, then the seller is not having right to lien. So the seller should not agree for this because law has given him this right. Okay. So the possession of the goods by the seller must not expressly exclude the right of lien. Now the fourth is the lien can be exercised by the unpaid seller only for the price. Means if the price is not paid, then only he can exercise the right of lien. But if price is paid and some other charges, dock charges and all, if those charges are not paid, then for that payment, right to lien cannot be exercised. So right to lien can be exercised only when the price is not paid. Okay. Next is where an unpaid seller has made part delivery, then he can exercise right to lien on the other part. Means if the seller had agreed to give 15 goods to the buyer, he has sent 10 goods and he is waiting for the payment, but the buyer is not paying him. Then for the other 5, means that now the seller has to give 5 goods to the buyer. So the seller can exercise right to lien on the 5. He can say, pay me the whole price, then only I will deliver the 5 goods. Okay. So he can exercise right of lien on part of the goods also. Next is the unpaid seller of goods having a lien thereon does not lose his lien by reason only that he has obtained a decree for the price of the goods. Means if possession is there, then the seller can exercise the right of lien, though he has filed a case in a court and the court has given him a decree also that he should get the price, he should recover the money and all. Though he is having a judgment, a decree in his hand, he can exercise the right of lien. These are the 6 rules relating to lien. We'll revise. The seller may exercise the right of lien as an agent. Possession is very essential. Actual possession is necessary to exercise right of lien. The third is the possession of the goods of the seller must not expressly exclude the right of lien. Fourth is the lien can be exercised by the unpaid seller on the price and not for other charges. Fifth is the seller can exercise the right of lien on the part of the goods also, though he has delivered some of the part. And the last is the unpaid seller of goods having a lien does not lose his lien though he has got a judgment or a decree in his favor. Okay. Now this right to lien will terminate when he delivers the goods to the buyer or the buyer's agent. Okay. If he lawfully obtained this possession, then the seller will lose the right to lien. That is, his right to lien will terminate when he either waives or either delivers the goods. So This is called as termination of right of lien. Now this waiver can be either express waiver or either it can be implied waiver. Okay, means the law has given him the right to exercise the lien, but if he says that okay, you take the possession, pay me afterwards, then his right to lien comes to an end because he has lost the possession. So there are three modes in which the lien can terminate. The first is if he delivers the goods to the carrier or bailee for the purpose of transmission to the buyer. Second is the buyer or his agent lawfully obtained the possession. And the third is by waiver of the right to lien. And this waiver can be either express or either it can be implied. Okay. Bye bye. We have to continue the lecture because we have not yet completed the other rights, and that is going to be continued in the next video. Okay. Bye bye.